We can now say aloud what sensible people have been saying sotto voce for years. In Britain, you may criticise Islam. You may say some Islamic doctrines need reform. You may even speak sharply about texts and historical practices, and the law will not automatically march you off to the scaffold. The Patrick Lee ruling makes that clear. The tribunal accepted that his position was Islamic critical, directed at doctrines and practices, not at Muslim people as such, and so it qualified as a protected belief under the Equality Act 2010. That is a significant clarification because it separates criticism of a religion from hostility to its adherents, just as our courts have been trying to do in other free speech cases. Once we see that distinction, a lot of the noise from the far right collapses. Figures like Tommy Robinson trade on the idea that Islam is already above criticism in Britain, that there is a creeping blasphemy law, and that Sharia is quietly supplanting English law. The facts do not support that story. The 2018 Home Office review and subsequent government materials state in the plainest terms that Sharia councils have no legal status, no criminal jurisdiction, and that where there is a clash, UK law prevails. That has been repeated again and again, as recent as this autumn. So there is one law in England and Wales, and everybody knows where it sits. There is one law also in Scotland. What then are these Sharia bodies doing? Mostly what the London Bet Din has done for centuries for Jews, what Catholic tribunals and canon law does for annulments. They help believers square their religious life with their conscience. They deal with religious divorce, inheritance questions, sometimes with community mediation. They operate under the Arbitration Act, where only where parties consent, and even then they must stay inside English public policy. That is not a rival legal system. It is legal pluralism inside a clear hierarchy with Parliament and the courts at the top. It's also worth saying, because the tabloids will not, that most users of Sharia councils are women wanting an Islamic divorce that civil law cannot give them because their nikah was never recognised. Abolish the councils tomorrow and you do not suddenly liberate these women, you strand them. That is why the 2018 review didn't call for closure, it called for regulation, for mandatory civil marriages alongside nikah, for better information about women's rights, and for intervention where a council strays into areas like domestic abuse or child custody that belong in the civil courts. That is a measured British answer. So, why should we insist on the right to discuss Islam? Because, firstly, Islam is a great historic faith present in British life, and serious citizens talk about serious things. Second, in fact, if you were to go to Russia, live in a Russian family, you would find small talk, the sort of small talk that we specialise in the UK, doesn't exist at all. Everybody talks about serious things, so we should. Second, what we have seen what happens when officials silence scrutiny for fear of being called racist. Rotherham is the case everybody reaches for, and rightly so. There, the failure was not so much speech, but too little. Not too much criticism of cultural practices, but too much timidity about raising them. Honest description protects vulnerable people. Dishonest quiet harms them. Mr. Lee said as much, and the tribunal accepted that his concern was about doctrines that seem to authorise conduct which in Britain is criminal. That's a perfectly intelligible line of argument in a liberal democracy, but honesty runs both ways. If you wish to criticise Sharia, you must know what it is. Sharia is, in classical sources, is a path to the water, not a ready-made penal code. It is interpreted, contested, and plural. It is not the Saudi criminal code. It is not the Taliban's latest edict. British Sharia councils are advisory bodies created in 1980s London, not caliphal courts from Damascus. To speak as if every Muslim in Bradford is one Friday away from amputations is not criticism, it is folklore. Our law will protect criticism because criticism can be answered. It will not be impressed by folklore and bias and smut. We should also remember that English law has always been good at absorbing religious particularity without losing its supremacy. Jewish gets, Catholic annulments, Islamic finance under the Finance Act so that Muslims are not punished for avoiding interest. All of these have been accommodated. None of them dethroned the Crown in Parliament. So when pulpit or YouTube warriors shout that London is on the brink of Sharia, they're not describing Britain, they're describing a business model. There is, of course, a real problem, or there are some real problems. Some councils have used grandiose language about being courts. Some have allowed or appeared to allow discriminatory outcomes for women. Baroness Cox was right to highlight cases where women were pushed to use religious forums and not told of their civil rights. Those are not reasons to ban discussion of Islam. They are reasons to keep talking about it, to insist that every practice in this country is measured against equality law, to say to Muslim women, you are citizens of the United Kingdom and the family court is yours. That is how you prevent a parallelism from emerging. You expose, you regulate, you legislate. And this is where the far-right hysteria is so obviously mistaken. If you tell young white men that even the mildest criticism of Islamic doctrine will get them sacked, they will go to whoever promises to protect them, even if that person is reckless and bigoted. If instead you say that Judge Khan has now said that you may criticize doctrines, but you may not harass Muslims, then you take the heat out and you leave the cranks with nothing dramatic to sell. That is why this tribunal matters. It shows the existing law is perfectly capable of balancing free expression and protection from anti-Muslim hatred, so the cry that we must choose between silence and Sharia is false. And the talk we ought to be having in Britain is a grown-up one. Islam is present, British Muslims are citizens, Sharia councils exist but are bounded, some practices need reform, some criticisms are illegitimate, some speech crosses into targeting people rather than ideas, and the law already knows how to handle that. What we do not need is a fantasy of Islamic takeover. What we do not need is citizens who read rubbish. What we need is citizens, subjects of His Majesty, who read and discuss from legitimate and authentic and correct sources before they rant, who actually have done their homework. What we need is people who have read the Quran, if necessary, not the Tommy Robinson interpretation. What we need is people who are informed. The lack of information, the people who simply rant because they've read the headline on the front of the Sun, or because they've listened to a speech by Tommy Robinson. This is not discussion. This is prejudice. This is bias. But discussion about Islam is a good thing. Discussion about any religion is a good thing. Religion tells us something essential about culture and about our shared culture.